Good evening. I'm Hiram Chodosh, Dean of the College of Law. Welcome to the Leary Lecture. Before I introduce our distinguished speaker, I'd like to express the coupled humility and honor I feel tonight through our collective association with the rich traditions and the exciting future of this tremendous law school. With this lecture, we honor William Leary, the second dean, an outstanding exemplar in a long line of great deans, including more recently the late Lee Teitelbaum and our dear colleague Scott Matheson, whose mom is here tonight. Hi, Norma, how are you? I'm sorry that Scott could not be here tonight since he's solely responsible for attracting his dear friend, Professor Fallon, to join us. However, since he'll surely watch the lecture by videocast, I want him to know how indebted we all feel for his leadership and for the strong pillars of the school's promising future he helped to establish. So please join me in giving Scott a warm thanks. William Leary was the second dean of the College of Law. Like our speaker this evening, he hailed from New England. Born in Massachusetts, he received his A.B. degree in 1903 from Amherst College. He graduated from Chicago Law School in 1908 with a J.D. And for those of you who think I'm too young, I want you to know that when Dean Leary was appointed to the deanship in May of 1915, he was only 34 years old. He served a remarkable term of 35 years and took the school through 2 world wars and the Depression, and also served as the heart of its teaching program. Known well for his wit, intensity, and flair for the dramatic, he shifted from waxing as a philosopher on the role of law in mediating high conflict to impersonations of Jack Dempsey to illustrate the principles of assault and battery. Beyond his classroom performances, his stated aspirations for the school are instructive even today. Though not a scholar himself, he once wrote that I'd like to see a freer discussion of philosophical questions, a broader, more tolerant attitude, a deeper respect for others, and a truly intellectual atmosphere. The lecture established in Dean Leary's memory is now in its 41st year, having attracted many of the leading intellects in both the judiciary, from Traynor to Brennan, and the academy, from Rostow, Falk, Minnow, our very own Fordham, Brest, Rose, Amar, Sunstein, Lessig, Coe, and so many others. Given Dean Leary's great talent as a teacher and his philosophical and open intellectual values, I can think of no better choice for this year's Leary Lecture than the Ralph S. Tyler, Jr., Professor of Constitutional Law at Harvard Law School, Richard H. Fallon, Jr. You've all read about his impressive background, his exquisite education at Yale, both as an undergrad in the law school and at Oxford as a Rhodes Scholar, his clerkships with Judge Skelly Wright and Justice Lewis Powell of the Supreme Court. You've also read of his outstanding contributions in scholarship, service, and teaching, his prolific writing on the pressing problems of constitutional law, with 2 leading books on the dynamics and implementation of the Constitution, published at University Presses of Cambridge and Harvard. His leadership and service in the American Academy of Arts and Sciences and the American Law Institute, his wonderful reputation as a teacher, 2-time recipient of the Teaching Award at Harvard Law School. In these 3 areas, Professor Fallon serves as an inspiration and an exemplar for us all. Not only is he an expert on the constitutional issues confronting our courts of law, I understand he's also got a mean hook shot. And so whether in basketball or on the Constitution or on his faculty, he represents the rare and inspiring triple threat. Behind his extraordinary accomplishments are 3 very special intellectual and personal qualities. First, he has an uncanny ability to reduce what may appear to some as constitutional confusion to a few simple lessons, without understating what he himself has called the Constitution's daunting, sometimes maddening, and occasionally inspiring complexity. Second, it's clear his writing is motivated by deep values of constitutionalism and his dreams for a better future. But these never seem to interfere with his philosophical insights on the limits of legal documents or his sharp observations on the real Constitution, the implemented Constitution, the Constitution in practice, the dynamic Constitution. Finally, Dick Fallon is probably about the nicest person you'll ever meet, and it's easy to understand why he's so popular with his students and his colleagues. I hope you'll each have a little time to chat with him after the lecture. So please join me with a very warm welcome for the 41st Leary lecturer, Professor Dick Fallon, and his lecture, Executive Power and the Political Constitution. Dick, thank you very much.
Well, thank you very, very much. Thank all of you for this warm welcome. Thank you, Dean Chodash, for that. That was really over the top, that introduction. I think that's the only introduction I've ever had that even my mother would blush at, and that's saying something. I'm so delighted to be here. I've got such a warm welcome and such a beautiful place. I do have this indirect connection with the place through Scott Matheson, who's a long-time, dear, wonderful friend. I'm so pleased that his mother is here this evening. The one thing that Dean Chodash said about Scott that wasn't entirely true was that Scott waited until he wasn't dean anymore before he wanted me to come and give this lecture. I think because he had more trepidations about how it would go than perhaps Dean Chodash does, and especially in light of that introduction from Dean Chodash, I will be doing my best, such as it is. So my topic for today involves the constitutional obligation of the executive branch, if any, to obey judicial decisions specifying the rights and obligations of particular parties. So examples would be if the president detains someone as a dangerous enemy combatant and a court orders the president release that person, is the president constitutionally obliged to do so even if the president believes that it would be a disastrous legal and constitutional mistake to do what the court has directed the president to do? Or similarly, if a court orders the president to stop wiretapping telephones and the president believes that he has a constitutional entitlement to go on tapping those phones, and that what is more, those wiretaps are vital to the national security, is the president nonetheless obliged to obey the judicial order? Although this topic is thus defined as a relatively narrow one, I think it's relatively obviously also a timely one, and I think that in thinking about it, we may be able to gain some general insights into the way that constitutional law and our constitutional order generally work. So for purposes of thinking about the president's obligation to obey judicial decrees, I have always thought that the most fascinating case to ruminate over was the case of Ex parte Merriman. Ex parte Merriman was a case coming from the Civil War era. Early in the Civil War, the state of Maryland was threatened with secessionist forces possibly about to overrun the government there, and President Abraham Lincoln asserted an executive authority to impose martial law. And in Ex parte Merriman, what was at stake in a practical sense was the president's right power to declare martial law. But the vehicle through which the case arose was a petition for habeas corpus. And habeas corpus is the traditional legal writ pursuant to which people who have been detained and believe they have been unlawfully detained by the executive branch are able to go before a court or have a representative go before a court and have the court determine the legality of the detention. So in Ex parte Merriman, the technical legal question was whether President Abraham Lincoln had the authority under the Constitution to suspend the writ of habeas corpus or the right of Merriman and people like him to habeas corpus. The case was argued before the Chief Justice of the United States, Roger Taney, acting in the capacity not of a justice of the Supreme Court, but as what was in those days called a circuit judge or circuit justice. And in this case of ex parte Merriman, Taney held that Lincoln had no right to suspend the writ of habeas corpus. The Constitution says explicitly that in times of invasion or rebellion, the right to the writ of habeas corpus can be suspended, but the Constitution puts this provision in Article I, dealing with the powers of Congress, not in Article II, dealing with the powers of the President, and thus, said Taney, Lincoln has no authority to do it. This prisoner must be released, and he issued the writ directing the release of the prisoner with a direction that it should be delivered personally to President Abraham Lincoln, and I quote, in order that he might perform his constitutional duty to enforce the laws by securing obedience to the process of the United States. So Lincoln got the opinion from Taney and the order to release the prisoner, and he ignored it. Told the jailer, keep this person in jail. It's just too dangerous to be letting him out. There's a civil war on. He and others like him could pry the state of Maryland away from the Union. Having given that directive to his cabinet officials, Lincoln said nothing for a period of some months. Some months later, he wrote an address delivered to Congress in which he essentially argued that Taney was wrong about the Constitution. The provision for the writ of habeas corpus and its suspension contemplates that there will be constitutional emergencies. This was an emergency. There wasn't enough time to get Congress together to decide whether to suspend the writ, and so he just had to do it. And Taney was wrong in his reading of the Constitution not to understand that the emergency made it necessary and appropriate for him to do what he did. Now, as a matter of constitutional argument, in one sense, Lincoln may really have had the better of it. He may have been more persuasive than Taney. But the crucial thing, the striking, interesting thing about Lincoln's response was that Lincoln just absolutely avoided the question that I want to talk about this evening. Not the question who was right, whether Lincoln was or was not entitled to suspend the writ of habeas corpus, but the question under the Constitution, once the judicial branch has issued an order to the executive, including the President, must the President obey it? Now, in raising this question this evening, the timing is not entirely coincidental. We live at a time when we've got a president who's claiming very, very broad powers under the Constitution, claiming powers to do things in contravention of statutes written by Congress. It's not so far from that. It's not unthinkable to imagine that this president might at some point claim a prerogative to defy an order from the judicial branch. And so that's what I am concerned about. But I trust that no Bush partisan would think that I have somehow framed the question in a disrespectful way by putting Bush into the same category of analysis as Abraham Lincoln for purposes of pursuing this question. And so that's what I want to be doing. I want to be talking about the question in some general, abstract, semi-philosophical sense, not just Bush and Abraham Lincoln. And the one last preliminary before I'm into the substance of the analysis would be, I assume it would practically go without saying that in order to try to figure out what the president's obligations are or are not to obey judicial opinions, we've got to look to things other than what the Supreme Court has said. Because if we just assume that the Supreme Court is the one that gets to decide whether the president is obliged to obey Supreme Court decisions, then we've determined without really conducting any inquiry that the Supreme Court is the ultimate decision maker. And that's the question that I want to put in issue. Are there some circumstances, if so, what circumstances, in which the ultimate constitutional decision maker should be the president rather than the courts? Now, in thinking about that question, I begin with what I take to be common ground. And that common ground is that although we most often think of the Constitution as a charter of government and a guarantor of individual rights and liberties, in many ways the Constitution's most basic function is to constitute the people of this vast geographic expanse of land that we call the United States is one American people, united with a common political past, an understanding that we have a shared political future, and a sense that we are going to conduct our affairs together under the Constitution of the United States. And so when we talk about what the President ought to do, what the President is obliged to do, we're assuming that we're talking about what the President is obliged to do under our Constitution rather than under some better Constitution that somebody else might design. And when we argue about what the President ought to do under that Constitution, we've got a common frame of reference, a common vocabulary. We've got the language of the Constitution. But we've also got our constitutional history. And it's striking when we talk about what presidential powers are under the Constitution. We're interested in what our history has been and what our great presidents have done. We want to look in the history books and tell stories about what Washington did, and Jefferson and Jackson and Lincoln and Franklin Roosevelt. What they've done is just as important as what the courts have done in thinking about this issue of presidential power against judicial power. Thinking about judicial power, we of course think of the courts too. And we think of those situations in our history when we think that the courts have played a vital role helping to make the country a better country than it would have been otherwise. We think about cases like Brown against Board of Education and Marbury against Madison, where it seems to have been a great triumph for the cause of constitutionalism to have the courts play a leading role. But when we think about judicial cases, we also think about the cases in which courts seem to have gone wrong, those cases that seem to be negative rather than positive lessons about what the role of the courts ought to be. We think of cases such as Dred Scott against Sanford, in which the Supreme Court held that Congress had no power to prohibit slavery in the territories and that African Americans were incapable of becoming citizens of the United States. We think of cases such as Lochner against New York, in which the Supreme Court seemed to take recurrent steps to thwart the enactment of political regulatory legislation that was wanted by vast majorities of the American people in the name of fairness. And we could go on with other examples, too, of situations in which too much judicial power seems not to have served us so terribly well. In thinking about these cases of judicial power, some of them positive examples putting the courts in an excellent light, some of them negative examples that might make us more skeptical of a broad judicial role, I don't think that there is much, if any, consensus about where to put ex parte merriment. This case that I talked about a few minutes ago involving Abraham Lincoln's defiance of a decision by the Chief Justice of the United States. Surely merriment is not widely embraced as a great triumph on the part of the courts, but I'm not sure it is regarded as a disaster either. And so in light of our history, I think that most people do think that most of the time presidents will and should obey judicial decisions with merriment hanging a little bit in the background. So the notion that presidents could, should, will, should, are legally obliged to obey judicial decisions, a number of episodes in our constitutional history would tend to testify in favor of this proposition. Among them would be the Nixon tapes case going back to 1964. President Richard Nixon's, a number of his top aides were under indictment. Scandal overhung the White House. There was serious question whether the president had been involved in wrongdoing. And in that situation, the special prosecutor investigating White House wrongs tried to subpoena White House tapes. Nixon initially hinted that if ordered to surrender the tapes, he wouldn't do it. Finally, the Supreme Court entered an order saying that Nixon must surrender those tapes. He did, and when he did, I think it was nearly everybody's judgment that this was a great triumph for the rule of law. Here in the United States, no one is above the law, including the President of the United States. Another example in the same tradition would be the Youngstown steel seizure case going back to the 1950s. With the United States at war in Korea, President Harry Truman seized the steel mills to avert a strike. Truman claimed to have been acting in the national interest. The steel mill owners sued, claiming that they had a right to have the steel mills returned to them. The Supreme Court agreed. Upon that decision by the Supreme Court, Truman backed off entirely, returned the steel mills to their owners. And once again, I think people thought it was a great triumph for the rule of law. Final example in this vein that I'll give you would be the case of Cooper against Erinn, decided by the Supreme Court in 1958. That was a case in which the Supreme Court took the position that after it had announced its decision in Brown against Board of Education, every school official in the United States was obliged to desegregate the classrooms in his or her community, and that the executive branch of the United States government was obliged to back that up under the Constitution. The court said in this case the federal judiciary is the supreme expositor of the law of the Constitution. And its decision in Brown against Board of Education is the supreme law of the land, every state legislature or executive or judicial official being bound thereby. Once again, I think the judgment was, here was the Supreme Court standing up for what was right. The Supreme Court deserved applause. Anybody who wanted to stand in the Supreme Court's way was wrong. Now, I want to point out one important way in which Cooper against Erinn goes further than the cases that I've talked to up to this point. That way in which Cooper against Erinn goes further is that in every one of the previous cases that I talked about, what was at stake was whether the president or the executive branch had an obligation to obey a judicial order once that order had been entered in a particular case, so that the rights of the parties to that particular case had been adjudicated. In Cooper against Erinn, the Supreme Court went further, and it said once the Supreme Court speaks, pronounces some general legal principle, then the president and everybody else is henceforth obliged to obey that principle, to conform to its dictates, even in other cases that the court has not yet dealt with. So that's a very broad, very heady claim of judicial power. Once the Supreme Court speaks, everybody is obliged to take the Supreme Court as having uttered the last constitutional word. Its implication would be, for example, that once the Supreme Court had decided the Dred Scott case, Congress can't do anything to prohibit slavery in the territories, that Congress was somehow behaving unconstitutionally insofar as it went on pushing to try to limit slavery in the territories. It would imply that after the Supreme Court had decided Lochner that it was unconstitutional for state and federal officials to keep pushing the Supreme Court by enacting legislation to reconsider its decision. So that's a very heady claim. The Supreme Court speaks, now everybody else, it's time to shut up and accept what the Supreme Court has dictated. No more quarreling with us, no more pushing us to change our mind. And I want to come back to that later, but before I do, I just want to get out onto the table what might be viewed as another set of historical examples, a set of historical examples in which a number of presidents, including some of our greatest presidents, have insisted that they were not bound by decisions of the Supreme Court. So with more time, I would do this more slowly, but I'm just going to bang through them under the circumstances. Thomas Jefferson, third president of the United States, famously refused to obey a subpoena directing him to give evidence in a criminal trial of his former vice president and political enemy, Aaron Burr. Andrew Jackson, one of the great early presidents, had a variegated history of defying courts. As General Jackson, he had, while occupying the city of New Orleans at the end of the War of 1812, had disobeyed a specific judicial decree while he was president. He threatened the Supreme Court on various occasions, and there is a famous story in which the Supreme Court, having decided a case, Jackson said, as legend has it, John Marshall has made his decision, now let him enforce it, which Marshall, of course, was not competent to do, and he was getting no help from Andrew Jackson. Franklin Roosevelt, a president who became so frustrated with the Supreme Court that he tried to pack it, at least twice during his presidency, threatened the Supreme Court with disobedience if they decided a case contrary to his wishes. The Supreme Court in those two instances backed down. So Roosevelt was never put to the test, but he had let the justices know that if they decided a case that he thought important, contrary to the way he thought that it should be decided, that he wasn't going to obey. And then, of course, there's Abraham Lincoln in the case of ex parte Merriman. I've already said something about Lincoln. I'm going to say more about Merriman and Lincoln's views concerning executive obligations to obey judicial decrees before I'm done. But first, because I can't help it, because this is the way I think, I want to put in place three models reflecting ways in which somebody might think about the president's obligations, if any, to obey judicial orders. So, first possible way to think about it, what I'm going to call the pure judicial supremacy model. The pure judicial supremacy model would embody the position that the Supreme Court took in Cooper against Erinn. When the Supreme Court speaks, it enunciates those principles of law that all of us thereafter are obliged to live by. There can be no resistance to what the Supreme Court has said, either in the particular case in which the Supreme Court has uttered its pronouncements or more generally. Why is this so? I guess the answer would be because the Constitution makes the Supreme Court supreme with respect to the declaration of constitutional law. And more deeply, I guess, the explanation would be that when the Constitution gives us a Supreme Court, gives us a judicial branch of government, it does so for purposes of taking some questions outside of politics, take some questions outside the hands of political decision makers on the ground that political decision makers couldn't be trusted to make those decisions. They're too likely to make them in a way that would be expedient, political, not in touch with our long-term constitutional values. That's the job of the courts, and we should all respect the courts in doing that job and accept what the Supreme Court says with respect to everything. A second sort of polar approach would be what I would call the political constitution model. So if the judicial supremacy model thinks that the Constitution puts a number of questions wholly above politics and therefore in the hands of the courts, the political constitution model says what the Constitution does is to lay down in very general terms the outlines of a political structure of government that then need to be filled in by the three branches, but in a situation in which each of the three branches may have some special competence, something to add to the mix, and thus in a situation in which each of the three branches should decide for itself what the Constitution means. So the way this would play out, for example, would be if Congress passes a statute forbidding the president to engage in wiretapping, then Congress, when it enacts that statute, has to decide for itself whether that statute is constitutionally permissible or whether it trenches on the president's powers. So then suppose the statute has been passed. Despite that statute, the president goes ahead and engages in wiretapping. Suppose the president taps my phone and I go to court and I get the court to order the president, stop tapping the phone. When you do that, it violates the Constitution and laws of the United States. Now the court has had its say about what the Constitution requires. And then it's up to the president to decide for the president whether to obey that judicial order on the ground that it is the president's obligation under the Constitution to decide for himself or herself what the Constitution requires. Now, from a modern perspective, this seems unruly, maybe even unlaw-like. But if you think that the Constitution is to some significant extent a political document, then a certain amount of unruliness and controversy among the branches serves the salutary function of making the appropriate resolution of constitutional issues political issues that nobody can ignore, with the likely effect that it will be the voters at election time who get to decide which branch's interpretation of this broad, vague political language ought to prevail. So that's what I would call the political constitution model. And then there is the third model, what I would call the finality of judgments model. And the finality of judgments model tries to carve out some space between these two extremes. The Supreme Court speaks, and that's it for everybody for all time. And on the other hand, the president gets to decide for himself whether or not to bother to obey judicial orders, and says, when the courts decide a particular case, the president is obliged to obey and enforce that particular decision of that particular case, but not necessarily to accept every word that the Supreme Court has uttered as resolving how the president and other political officials ought to obey in future cases. In American constitutional history, the most famous defender of the political constitution, of what I would call the finality of judgments model, was Abraham Lincoln, interestingly in the context of the Dred Scott case. Dred Scott case, the Supreme Court says Congress can't prohibit slavery in the territories. Dred Scott is obliged to remain in servitude to his master. Lincoln said the court has decided that case. Once the court has decided that case, it would be incompatible with the rule of law for somebody to be refusing to accept that decree, for trying to pull Scott away from the person holding him in bondage. But the authority of the Supreme Court's decision goes no further. It can't stop Congress from trying to push politically the envelope, can't stop Congress from going on to try to stop slavery in the territories. If a judicial decision could do that, Lincoln said, the people would cease to be their own rulers. So Lincoln, there's a kind of tension built into this position. On the one hand, the Constitution is enough of a political document so that Lincoln thinks that after the Supreme Court has spoken, the public can keep up a drumbeat of opposition, as can Congress and the President, in cases other than that one specifically decided by the Supreme Court. But Lincoln said the Constitution is law. The rule of law requires respect for judicial decisions. Thus, in the particular case that the court has decided, what the court has decided must be obeyed. So, three possible ways of thinking about the president's obligation, if any, to obey judicial decrees. Which of these is the best or the right way? Well, my own view on this is that the history is pretty much inconclusive. It points in different directions. I've told you of situations where presidents proudly obeyed judicial decisions contrary to their interests, said this is what we have to do, this is what the Constitution requires. But I've also identified for you cases in which great presidents refused to accept that they were bound by the Constitution. I think that the language of the Constitution is less than wholly determinate too. Article 2 of the Constitution says that the President is obliged to take care that the laws are faithfully executed. You could read this as saying that when the courts decide a particular case, their decrees become part of the law that the president must execute. But you could also say the president must take care that the laws are faithfully executed, but the Constitution doesn't say the laws as interpreted by whom. Maybe it reserves that right of interpretation to the president. Language in Article 3 says that the courts have the power to decide cases. You could make the argument that when a court has decided a case, that means that the president is obliged to obey the decision. I think this is a possible reading. Indeed, it's the one ultimately that I'm attracted to, but I'm not persuaded that one gets there by linguistic necessity. So to try to figure out the president's obligations under the Constitution, given the indeterminate text, the indeterminate history and precedent, I think what somebody needs to do is to ask the question, what's the best way to read the Constitution in light of its history? What's the best way? With that question, what's the best way, including an irreducibly normative component? Which way do we get the better Constitution, the better constitutional law? And if the question gets put that way, then I personally cast my vote for what I described as the finality of judgments model. I wouldn't want to go so far as the judicial supremacy model, the pure judicial supremacy model. It seems to me that we've got to recognize the Supreme Court is capable of erring, sometimes erring grievously, and when the court does that, or people think the court has done that, for instance in the case of Dred Scott and slavery, or stopping progressive social legislation during the Lochner era, I think that drumbeat of pressure, publicity, is an appropriate thing. So I wouldn't want to go as far as the judicial supremacy model. On the other hand, I would be very reluctant to endorse what I described as the political constitution model. Frankly, I wouldn't trust the executive branch with making decisions about people's liberty in particular cases. I think that the pressures on the executive branch to want to do what seems expedient, sometimes to exaggerate the demands of national security may be too strong. So I wouldn't want to go that far either. On the whole, it seems to me that what I described as the finality of judgments model carves out the closest thing that there would be to a happy medium. It's a kind of accommodation. People get to continue to press the Supreme Court to change its mind when the decisions that the Supreme Court is making have some substantially political component, as many of their decisions do. On the other hand, the rule of law, safeguard of individual liberties requires obedience of judgments in particular cases. Now, as I say, this seems to me to be the best compromise. It's based on predictions. It's based on predictions about the way our institutions of government will work, about how different institutions of government are likely to function best. And worried about how different institutions are likely to function best, somebody might say this. The implication of the model that you've just accepted is that Abraham Lincoln was wrong in ex parte merryman. And if Lincoln was wrong in ex parte merryman, then the implication seems to be that Lincoln just should have laid down, done what the courts had ordered, and maybe the Civil War would have been lost and the whole course of our American history would have been different. So don't you want to adopt the following adjustment to this position? Don't you want to say the president should have to obey the courts except when the president thinks the courts are grievously wrong? So you might say this, but then, of course, the problem is there's always going to be this question about whose judgment about whether the courts are grievously wrong. What the Constitution has to do is ultimately to put decision-making responsibility in somebody's hands, the hands of some institution. Which institution? I'm going to say in terms of the best way to read the Constitution and the best way to think about presidential obligation to obey judicial orders, I'm going to say I think the best reading of the Constitution says that in particular cases the decision is for the courts. The president is obliged legally to obey, and that Lincoln was in violation of the Constitution in ex parte merriment. Now, it's this thought about Lincoln that I want to muse about as I move to the conclusion of this lecture. Because to say that Lincoln, probably our greatest president, excuse me, violated the Constitution, excuse me, it's not exactly to assert a paradox, but it probably doesn't fit very well with the way most of us think either about Lincoln or about the Constitution. And so to begin to muse, I've got just two thoughts. The first thought is that I think we make a mistake when we say that what is constitutionally right is always morally right. It's possible in ex parte merriment that Lincoln was legally and constitutionally wrong, but that he was morally right. Jefferson took the position strongly that the obligation of presidents and elected officials to obey the law is a very high obligation, but not necessarily the very highest obligation. He, in fact, thought that he had violated the Constitution when he effected the Louisiana Purchase. But he thought nonetheless he was right to do it because he was responding to the call of a higher good. I think that in many situations we get a better understanding of both legal responsibility and moral responsibility if we understand that the two sometimes can come apart, and that some of the very hardest situations in which high public officials may find themselves may be ones in which their legal duties and their moral duties pull in different directions. The second point I want to make is that we make a mistake if we assume that the legal obligations of the president, as defined by the courts, will necessarily be enforced. Ex parte merriment is a clear case here. When we move from the identification of legal obligations to their enforcement, no constitution can guarantee its own enforcement, and certainly no constitution could guarantee the enforcement of judicial orders, as the case of ex parte merriment illustrates. Lincoln defied the judicial order. The people to whom he directed his orders went on obeying him. There were a few criticisms in newspaper editorials, but Congress took no action to impeach Lincoln, and the citizens of the non-seceding states continued to respect his moral authority to govern throughout the Civil War. Now, the fact that the Constitution was not enforced against Lincoln does not mean that the Constitution cannot be enforced against any president. Excuse me. And here, the case of Richard Nixon and the Nixon tapes case would be illustrative. When Nixon handed over those White House tapes, he did not, I think, hand them over because he had seen the constitutional light that it was his pure legal duty to do so. Nixon handed over those tapes because he knew that if he didn't, he would be impeached immediately, and his refusal to hand over the tapes would be treated as an impeachable offense. So when we put Lincoln in ex parte merriment together with Nixon in the Nixon tapes case, I think what begins to emerge as a kind of lesson is that even if the president is legally obliged to obey judicial orders, as I've argued the president is and should be regarded as being, there's a kind of truth still, a non-normative descriptive truth to what I described earlier as the political constitution model, under which each branch of government gets to decide for itself what the Constitution requires. Because if a president decides to defy a judicial order, then what the president effectively does is to create a situation in which enforcement and responsibility for enforcement rest with Congress and ultimately with the American people through the mechanism of enforcement of impeachment by Congress or insistence by the American people that a defiant president should be impeached. Now, at the present time, I think it's safe to say that the American people begin with a pretty strong intuitive presupposition that the president must obey judicial orders, that it would take a pretty extraordinary situation before the president could be excused for not obeying a judicial order. But as the case of Ex parte Merriman reminds us, times and attitudes can change, and the people may be unusually willing to accept presidential defiance of judicial orders in times of perceived emergency. A president, including the president, always could decide to defy the Supreme Court and take his chances with Congress or the American people. To say this, for me to say this, is certainly not normatively to endorse this state of affairs. As I've said, I think normatively the best understanding is that the president is legally obliged to obey direct orders of the judicial branch and especially the Supreme Court. But what I'm saying now is simply to recognize that it is always a possibility in our country that a president who defied a judicial order could escape punishment, could even be applauded for doing so. Whatever the law may be, courts cannot enforce their own orders. And that being the case, the ultimate foundation for our constitutional law and our constitutional order could not be the courts. Ultimately, in the long run, it has to be the people themselves through their political insistence that the Constitution be obeyed. Having come this far, I will confess at the end that this is not a novel insight. When asked what kind of a government the Constitution created, Benjamin Franklin made my essential point when he replied, "A republic if you can keep it." Thank you.
We'd love for Professor Fallon to take some questions. So, yes. I actually think that the debate about signing statements is misconceived in various ways. Presidents have to interpret the law in order to apply it. And when a law is vague or ambiguous and a president says, just so everybody understands how I'm going to read this vague or ambiguous law, I don't have any problem with that whatsoever. I don't think that that necessarily contradicts any of the models that I have talked about so far. Having made this as the general point, I would say, not meaning to sound too much of a political partisan, what I think is objectionable about the way this administration has used signing statements is that this administration has used signing statements as a way of concealing issues from both the courts and the American people rather than taking a position. I read this legislation as taking a position that is unconstitutional. I'm therefore going to veto the legislation so that Congress gets to consider my judgment that it's unconstitutional and see if it wants to override the veto. And I'm going to be completely upfront and open about my understanding to give somebody the opportunity to challenge it in the courts. So what I object
too, about the way this administration has used the signing statements is that it has failed to put things clearly, publicly before the American people and the courts. But in principle, I don't have any problem whatsoever with signing statements because I think much legislation is vague, is ambiguous. It is to be desired rather than decried when a president lets the people know how he or she reads that vague or ambiguous legislation.
I'm not clear that this thesis that you presented deals fully with the problem of Congress's power to withdraw jurisdiction from the court.
No, I didn't mean to be biting that one off either. Yeah.
At least not in 1 hour. But we do have a significant illustration of that that's come up in the most recent legislation in which allies of the president joined with the president in pushing to a conclusion a position that says there is to be withdrawn the authority to provide habeas relief in critical cases. That raise precisely the questions on which we need judicial intervention.
Right. Okay. So this is I'll try to unpack the question a little bit for people who may not have understood precisely what is at stake. But it's one of the most vexed questions in constitutional law and in federal courts, which is a hyper-technical subfield of constitutional law. But basically, the problem comes about in the following way. The Constitution contemplates 3 branches of government, President, Executive Branch, Congress, and the Judicial Branch. But the article of the Constitution dealing with the Judicial Branch, Article 3 of the Constitution, gives Congress the power to create exceptions to the jurisdiction of the courts. And thus the question arises, if Congress writes legislation that totally takes away from the courts any opportunity to pass on the constitutionality of something that the executive branch is doing, is what Congress is doing a permissible exercise of the power to limit the jurisdiction of the federal courts under Article 3, or is it somehow in total violation of the general spirit of the Constitution, which contemplates judicial review as a check on the executive branch? It's a very, very, very complicated question. And I'm just an inveterate difference splitter, which means that there's nobody that I can ever really please, except my mother, as I mentioned at the beginning, who's pleased with everything that I do. My own view is that in cases arising, presenting constitutional issues here within the United States, the withdrawal of jurisdiction is unconstitutional. But against the background of our history, it would be hard, if not impossible, to say that the Constitution requires the existence of courts here in this country to review the constitutionality of what is being done outside of the United States. For example, in Iraq or Afghanistan. We've gone through hundreds of years of constitutional history without courts exercising that power. And then so to tie this back to the most recent debate, from the perspective of somebody like me, the question becomes, is Guantanamo Bay, where much of what people want to challenge is going on, more like the United States, where I think it would not be permissible for Congress to cut the courts wholly out of the picture? Or is it more like Iraq, where I think it is constitutionally permissible for Congress to cut the courts wholly out of the picture? And with the question framed that way, I say I think Guantanamo is more like the United States than it is like Iraq for relevant purposes. But this is hard, technical, as well as broadly political, theoretical stuff.
Follow-up
Well, I tried to give in the response to that, from whence would the consequences come. The Nixon case, if the president refuses to obey, then Congress can impeach. If Congress refuses to impeach, the people can rise up at the next election and demand a Congress that will impeach. If the Congress impeaches and the president refuses to go anyway, then one can expect that other officials in the government would say the president's been impeached, that person is no longer the president. The real president now is the person who previously was the vice president, and if the people insist that the law be enforced in that way, it will be enforced. There's one sense in which I am describing the law the way that it is, because I think it's important to understand. I'm being a little preachy here. I usually try not to be a little bit preachy, but I am being preachy here. The success of the enterprise of constitutionalism in the United States may depend in part on courts, and it depends in part on the president, but what really makes the whole thing go is the commitment of the people of the United States acting most directly through Congress to government under law. Yes, let's have some faith in the courts, but let's not have too much faith in the courts. Let's put responsibility where it really lies. And thus I end with Franklin, a republic if we can keep it. A high value.
High value detainee program. Could you describe that briefly? Pros, if any, which I think you're not going to pick on. Cons, and then the recent Military Commissions Act, I understand it authorizes, legalizes some of the CIA and then going forward, how to support forward.
Right. Okay. So now I have again this feeling I'm being asked to teach a federal courts class. There are actually a couple of people in this very room who've slept through my federal courts class, and they could tell you that you're just pulling me down the wrong road. You don't want to go here. I don't know all the details about the detainee program, the secret detainee program being operated by the administration, in part for the very good reason that the administration has gone to great lengths to stop me and everybody else in this room from knowing a great deal about what's going on with the detainee policy. The Military Commissions Act limits, but does not wholly preclude. It's very technical. It's very hard even to describe what it does. There's no doubt that if the government wants to avoid a situation in which what it does is reviewable by the courts, it can do so under the Military Commissions Act, essentially by keeping detainees out of either the territory of the United States or Guantanamo Bay. If the government brings those detainees either into the United States or into Guantanamo Bay, there is some judicial review, but very limited judicial review. I'm looking at that look on your face. I can keep on talking, but I really don't think you want me to in terms of these technical details. I think that I think again my difference splitting nature. I actually think that most of what the Congress has done under the Detainee Act is constitutionally permissible, but highly regrettable as a matter of policy, and that there's a little bit of it that is unconstitutional. Mostly the part that is unconstitutional has to do with detainees in either the United States or Guantanamo Bay rather than Iraq or Afghanistan or someplace else in the world, where the Military Commissions Act is written in such a way as to be manipulable by the executive branch to keep the courts wholly out.
Let's take two more questions.
Two more.
There's a hand over here.
So
Wow, you're a potential A+ student in this federal courts class that the two people right in front of you slept through. No, you got it. Absolutely, flatly, exactly right. And my view about this, one of the things that I was trying to do in this talk was simultaneously to keep in mind the picture of Abraham Lincoln and George Bush, because it would be my instinct that if I could make a rule and say this is the rule that will be followed by Abraham Lincoln and this is the rule that will be followed by George Bush, I would make up one rule for Abraham Lincoln and another rule for George Bush. But the law can't do it that way. It's got to be the same rule. So it's going to be the same rule, and we don't know going forward what our presidents are going to be like. And in the situation that you described, I wanted to say, under what I called the finality of judgments model, that if the Supreme Court issues a ruling saying, President Bush, you've got to stop tapping Fallon's phone, but the president thinks, well, Fallon actually wasn't such a big fish in this terrorist thing anyway. And so I'm going to stop tapping his phone, but I'm going to go on tapping Professor Kogan's phone. Then that would be permissible under this finality of judgments model. And when I would make that permissible, it's because the case that in some ways I'm really worried about is where a Supreme Court issues a ruling that I think is terrible, such as the ruling in this Dred Scott case, that Congress can't try to stop slavery in the territories. And for cases like that, I want to say, yes, the president has to obey the specific order, but insofar as other people, other cases are involved, then it's okay to be trying to push some resistance, push back at the Supreme Court a little bit and see if you can get the Supreme Court to change its mind. Because just as we've had good presidents and we've had bad presidents, we've had good Supreme Courts and we've had bad Supreme Courts. And that, sadly, is the way human nature is. There are good people, bad people, good governments, bad governments, good presidents, bad presidents, good Supreme Court justices, bad Supreme Court justices, and we need the best rule that we can do to get along, understanding we're going to have some of the good and some of the bad.
I first wanted to admonish Dick that he's not allowed to learn that young lady's name, because she's coming here to law school, not to Harvard. I was going to ask one last question, perhaps, and it picks up on this. I'm not sure I understand the difference between the final judgment's position and judicial supremacy, given the role of precedent. So I wanted to know how the role of precedent factors in, because certainly we don't have a system that just decides each case on its own without consequence to future similar cases. And so I just wonder if you've thought through how precedent factors into this.
Well, probably not well enough, but I've not been wholly inattentive. And so I guess I would say there are two things. One, lawyers know, even if people who aren't lawyers don't, that lawyers can be enormously ingenious in distinguishing precedents, and to say, well, we don't want to quite fess up that we've made a mistake, but we're going to say that the case we decided in the past was unique in one or another way, so that we don't need to treat future cases the same way. The other thing is that precedents do from time to time just flatly get overruled, and a number of those precedents that people would think were most objectionable in American constitutional history did end up getting flatly overruled. That was the case with the notorious Plessy against Ferguson decision, which said that separate but equal was okay with respect to separation of the races. That was true with respect to Lochner. Dred Scott got overruled in a less happy way by a civil war, and so I don't want to be ending on that note. But no, precedents do sometimes get overruled, and it's a healthy thing that sometimes precedents should be overruled. If we got to a situation in which they could never be overruled, the Supreme Court decided once and was just so dug in that it was never going to change no matter what, then Lincoln said, and I don't think he was wrong about this, we would cease to be our own rulers. It's partly a political constitution. That's the tension. There's this rule of law demand on the one hand, but it really is partly a political, debatable document about which we are all entitled in some way and at some level to have our say. And again, my preachy moment for the night, it's our collective say that makes the whole Constitution go.
Before we retire to a reception out in the foyer to discuss how the case of Kogan and Fallon really differ, I'd like to just say that maybe state one profound disagreement, and that is that my intro was certainly, as the lecture showed, not over the top. So thank you, Dick, so much. Thank you.